NMC Health collapsed after disclosing more than $4 billion in hidden debt. NMC Health was once a crown jewel of the UAE healthcare sector, a sprawling network of hospitals that expanded with aggressive speed. By 2017, it had achieved the ultimate mark of corporate prestige. It joined the FTSE 100, the index of the 100 largest companies listed on the London Stock Exchange. To the public and the investors, it was a success story of growth and stability. But beneath the surface, a massive financial void was opening. In 2020, the facade shattered. The company collapsed after disclosing more than $4 billion in hidden debt. This wasn't just a bookkeeping error, it was a systemic failure of transparency that left billions of dollars missing and investors devastated. To understand how a FTSE 100 company hides $4 billion, you have to understand the mechanism of the audit. When a company is listed on a public exchange, it is required to have its financial statements verified by an independent third-party, statutory auditor. For NMC, that auditor was EY, one of the Big Four accounting firms. The auditor's job is to provide an opinion on whether the accounts are accurate. From 2012 to 2018, EY gave NMC an unqualified opinion. In the world of auditing, an unqualified opinion is the gold standard. It means the auditor believes the financial statements are fair, accurate, and free of material misstatement. For 7 straight years, EY told the world that NMC's books were clean. But the reality was a maze of off-balance sheet debts. An off-balance sheet arrangement is a way for a company to keep certain liabilities, like loans or guarantees, out of its main financial statements. This makes the company look less indebted and more profitable than it actually is. In NMC's case, the administrators later alleged that these were undisclosed guarantees. Essentially, the company had committed to paying back billions if certain conditions weren't met, but these obligations never appeared in the reports seen by shareholders. The administrators, led by Alvarez and Morsel, argued that this was a pervasive and collusive fraud perpetrated by the company's main shareholders for their own benefit. The turn came in December 2019. Muddy Waters, a research firm known as a short seller, investors who bet a company's stock price will fall, began questioning NMC's financials. The impact was immediate. The market reacted to the suspicion of fraud, and NMC shares tumbled by almost a third in a single day. The short seller's report acted as a catalyst, pulling the thread that unraveled the entire operation. Shortly after, the hidden debts were revealed, and the company imploded. The aftermath was a legal war of attrition. The administrators of the collapsed company sued EY in London, seeking nearly £2 billion in damages. The core of the accusation was negligence. The administrators claimed that EY had failed to get proper access to NMC's books and missed billions in unreported borrowing. Specifically, they alleged that if EY had simply inspected the general ledger, the master record of all financial transactions, the fraud would have been identified quickly. Their lawyer, Simon Salzedo, described the audits as some of the most fundamentally flawed examples of big firm auditing to ever appear in a UK courtroom. He argued that while one wrong opinion might be a mistake, 7 wrong opinions in a row is carelessness. E fought back with a different narrative. They didn't claim the fraud didn't happen, they claimed they were victims of it. EI argued that NMC's senior personnel had actively manipulated the accounts and hidden the fraud from the auditors. They contended that the administrators were asking them to do the impossible, uncover a collusive fraud being covered up by the very directors and management they were supposed to rely on. This created a classic legal deadlock. Was the auditor negligent, or was the fraud so sophisticated that it was designed to deceive even a professional eye? While the audit battle raged, other legal fronts opened. The company's founder, Indian tycoon B.R. Shetty, was brought into the litigation. In a striking reversal of the narrative, Shetty's own lawyers later claimed that he had been the victim of a debt-fueled Ponzi scheme. A Ponzi scheme is a fraud where returns are paid to earlier investors using funds from new investors, rather than from actual profit. This suggested that the rot in NMC's finances went even deeper than a few hidden loans. By November 2023, the UK regulator, the FCA, stepped in. They found that NMC Health had committed market abuse by publishing materially inaccurate financial statements. The regulator's censure confirmed what the market already knew: the company had lied about its debt to the public. The final chapter of the legal saga arrived in 2025 and 2026. A high court trial began in May 2025 and ran through October. The administrators were seeking roughly $7 billion in damages, but before the court could issue a ruling, the case vanished. On January 29, 2026, a court order revealed that NMC Health had withdrawn its lawsuit against EY. The settlement remained confidential, and the terms were not disclosed. EY stated they were no longer in dispute with the administrators, and Alvarez and Morsel confirmed the claim was resolved without any admission of liability from EY. In the end, the missing billions were never recovered through the courts. The auditors walked away without admitting they missed the red flags, and the shareholders were left with the wreckage of a company that looked perfect on paper until the moment it ceased to exist.